Namaskar, Dilip Singh Advocate. You are most welcome to my channel Journey of Constitution of India. Only yesterday I read a news about Himachal Pradesh High Court which said on 6th of August 2020, I quote, choosing between sureties and deposits accused is the queen and let her be. This is a very philosophical way it has been communicated that the accused should have the choice between bringing surety or depositing the bail amount in the court. The issue was bail amount. So the issue was whether it can be insured through surety or by a cash deposit in the court. The fact that the accused was granted a bail with surety, the accused was from West Bengal and the matter was in Himachal Pradesh, and it was very difficult for the surety for travel from West Bengal to Himachal Pradesh. So he approached the High Court that he should be given the liberty to deposit the amount in the court. The purpose of bond is to secure presence of the accused, and the purpose would be served even by depositing the cash amount. Interestingly, the High Court observed that the lawyers have a duty to apprise the accused of the existence of a provision of a cash deposit under section 446 of CRPC. But that what my take is that if it comes from the counsel to the court to deposit of the cash, it is not taken in the good sense, and it is a doubt from the mind in the mind of court that the accused may not come for the trial. So the important point is what I would say that today there is a good number of cases. Why I am quoting it here, because there are a good number of cases that accused has to face out of his home state or hometown, and it is very genuine difficulty for the accused to get surety of that area. So in this today's world, when every person has a unique identification number as Aadhaar card, and of course which was not available some 5 years back, so a new approach needs to be developed in case of surety for bail, and we need to revisit that the provision, and we should make the provision to some different. So we should get some way out of it. Just imagine if I ask you to think, what if the court in Himachal Pradesh directs the local magistrate or police station in Kolkata or in West Bengal in this case, where the accused resides, to take the surety and report it electronically to the court in Himachal Pradesh? But this needs necessary amendments in CRPC, and if it is amended in this way, very simple approach, very simple will be for an accused to give it surety, and the court burden will also be reduced. I have quoted this case of Himachal Pradesh because I want to make this point here. Now, because what I feel that criminal jurisprudence in India in last 72 years after independence has developed significantly, and we do not need to go to search the law in US or British system to find out the solutions faced by the Indian legal system. While reading the report of Law Commission, of which I am discussing, and in the previous video I have discussed, I realized that still the Commission tried to explore the solutions of the Indian bail system in British and American system. And a good number of pages have been invested, or it has been written in the report about the India, British and UK system, UK system and US system. While I think that Indian judiciary and Indian approach should be to find out the solutions in the Indian system and Indian society. Let us start our journey from the point where we left in the last video. So now you are watching part 2 of the future of bails in India. The Law Commission fairly conceded that long jail of an accused is against the very notion of fair administration of justice. We need to find out the alternative methods for ensuring the appearance of accused on bail at the time of trial. At the same time, we need to understand that the state has a duty to protect its innocent citizens from those who are likely to harm them, means the accused. Let us see the commission has to what commission has to say on arrest. Commission considered several guidelines given by the Supreme Court in various cases on arrest, and more particularly of Arnesh Kumar case in 2014, because this commission was given the work in 2015. But commission thought that it may be difficult to enforce the guidelines given in the Arnesh Kumar case, and every case, but and particularly in case of arrest. But the law commission recommended that it is better to streamline the case of arrest by making it mandatory for the police officer before arresting to write down his reason of arrest, and this will give an opportunity to the judicial officer to find out whether the arrest was necessary or not. And it was made incumbent on the that investigating officer in this recommendation that he will enter into the daily diary register with written, and thereafter he will get the written approval by the police officer who is in charge of the station house, police station. And according to me, this is a welcome step. Why I'm saying so, why this reason of arrest is so important, because the reason recorded by the police officer will be available before the judicial scrutiny of the before the judicial officer to check the arbitrariness and discrimination played on the part of the police officer. The commission recommended that section 50 of CRPC be amended accordingly. Now, the second aspect on which the Law Commission studied is default bail or statutory bail and remand. Law Commission considered the provision of statutory bail in detail, and the non-completion of investigation. It was recommended that the non-completion of investigation shall not be deemed to be a sufficient cause to extend the remand of the accused person. The magistrate has to consider the things in totality and pass a reasoned order before extending the remand. A police remand may be granted, but for compelling reasons, and magistrate has to apply his mind. He has to be vigilant before before extending the remand, and magistrate has to give reasons for not granting the statutory bail, which is provided in section 167 of CRPC. One important issue is of his supplementary charge sheet, which is taken by the investigating agencies always. The court should strictly enforce the rule that supplementary charges cannot be filed to fill the gap, but only to add the information that becomes available subsequently. The magistrate must examine and verify the case diary which is placed before him at the time of remand. There is some very good rules framed by the various high courts, and including our Delhi High Court and Delhi High Court rules, which has framed rules regarding the remand of accused person in custody, which ought to gain wider acceptance and which should be following with consistency and uniformity while giving the remand. Commission considered the section 309 in very detail. While section 309(1) directs the expeditious trial on day-to-day basis and witness should be recorded without giving adjournment, but in reality it is not possible because our trial courts are very heavily burdened and cannot dispose of the trials by holding them in cannot be directed and pressured to dispose of the cases by holding day-to-day inquiry. So one of the most relevant and important provision is striking at the root of the issue is section 309 subsection 2 of CRPC. Because once cognizance is taken, it comes into play where the trial is postponed or adjourned. The court may remand the accused in custody, and he can extend the custody. Practice adopted by court in case of remand is very mechanical, and in mechanical manner it is remand is extended, and hardly it happens that the court considers at the time of remand that whether the accused can be enlarged on bail or not. Amendment is suggested by this commission to the effect that it should provide in section 309 subsection 2 of CRPC, explaining if accused is in custody, judge has to record reasons for not releasing him on bail for and or further extending the custody. This will very much facilitate the process of releasing the accused or under trial who is spending a considerable time in incarceration before during the period of trial. In special laws, investigation agencies it should be incumbent on the investigating agencies to continuously update the court about the development in investigation, so that court can consider the thing, and if it is found that the delay in investigation is caused due to investigating agencies and not due to the accused, then the court can consider to release the accused on bail. Another important provision in which related with the remand is 166 and 167 of 7 of CRPC, and which deals with the remand. And particularly in this case, what is seen that the non-completion of investigation is taken as a point to extend the period, and the magistrate has to consider it very seriously at the time of extending, not releasing the accused on the default bail or statutory bail, or simply extending the time of remand on the request of the investigating agency that the investigation is still going on. The remand to police custody may be granted only in cases where there is real necessity, but and on the basis of the not on the basis of the general statement given by the police officer, but on evaluation of the situations where it needs really police custody or not. The magistrate shall examine the thorough manner the case diary which is placed before him at the time of extension of remand. So this provision of 167 as well as 309 are very important, and this has been dealt in the very detailed manner by this law commission and in this law commission report. The other important point is the conditions that may be imposed in bail. The prosecution has necessarily essentially it has to show that through evidence that the accused is at the risk of absconding or likely to interfere with the judicial process or likely to commit the same offences, the accused should be considered eligible to release with or without the financial obligations. So there should be some finding on the part of investing agency to show the court that these are the threats involved. The commission suggested that the court should consider to deposit of identity card, particularly in case of poor persons, identity card like Aadhaar card or driving license or the other documents which are issued by the government, and these documents should be considered as the deposit or as a condition, and thereafter a certified copy may be given to them so that it can be used by the accused person in his day-to-day life. So court may impose other valid restrictions to ensure the maintenance of law and order or peace or public safety. Just imagine the situation faced by an Indian system. Imagine a situation faced by the Indian system, and particularly due to the unequal social and economic conditions of the society. So the solution of these problems would also emanate from the Indian society. We would, and the court has to, and the law framers had to consider the peculiar circumstances, particularly poverty and migrant laborers and this kind of problem which are being faced, which are prevailing in our Indian society, and how to tackle these problems by the legislative measure. We would halt our this journey of this part 2 of future of laws, the future laws of bail and arrest here, and we will conclude this journey in part 3, where we will take the para-wise and the section-wise amendment inserted and recommended by the Law Commission in its report. Thank you very much for watching this video. And the part 1 of the series has been highly appreciated by the viewers. So before watching it, I would request you to kindly watch the part 1 of this series so that a continuity can be with you. Please share your views in the comment section of this video. and it will help me to improve the contents and to understand your point of view. Thank you very much. Please wish me good luck by subscribing to my channel if you have not subscribed. Namaskar.